If you have ever signed a non-compete during a merger, listen up. Today we are looking into two things. 1. What happens when a company merger forces an employee to sign a sweeping non-compete clause, only to fire him shortly after? And 2. The 3 pencil rules in contract law. Welcome to 99 Rights Online, your crash course in rights, rulings, and real-world justice. We simplify the law without dumbing it down because informed citizens make powerful communities. Now, this case originated as a suit by Eldredge White, a former employee of Fletcher, Mayo Associates Inc. FMA, seeking a declaration that the non-compete covenants he signed were unenforceable. In 1981, Eldredge White was employed by FMA, a marketing and advertising company. He held a 4.62% ownership interest in the company stock. And in 1982, FMA merged with Doyle Dane Bernbach International Inc. Now, White voted in favor, receiving Doyle Dane stock worth $145,000. This was a condition of the merger, and White was required to sign non-compete covenants. But only 3 other employees signed similar covenants. Shortly after the merger, White was terminated. So, White filed suit challenging the enforceability of covenants. The trial court found covenants overbroad but edited them to make them enforceable, granting an injunction. The central issue here is twofold. Were the non-compete covenants enforceable as part of the sale of a business, or should they be treated instead as employment contracts? And second, did the trial court make a mistake by blue penciling, rewriting the covenants to make them enforceable? Alright, law nerds, grab your school supplies because today we're talking pencils. Not the ones you chew on during finals, but the 3 pencil rules in contract law. Yup, courts basically decide cases with red, blue, and purple pencils. Let's sharpen them up real quick. So here's the rule. In employment contracts, non-competes only fly if they're narrowly tailored, strictly limited in time, territory, and otherwise reasonable. If they're overbroad, judges can't swoop in with a magic eraser to fix them. That principle comes straight from Rita Personnel Services vs. Cott. But when it comes to selling a business, the rules shift. Non-competes can be enforced to protect the buyer, even if they're broader than what would be allowed in an employment setting. That doctrine comes from Jenkins vs. Jenkins Irrigation. This is all. Depending on whether you're an employee or selling your company, the pencil courts pick red, blue, or purple, which can make all the difference. So, let's review those rules real quick. Red pencil rule, strict all or nothing. Courts invalidate the entire restrictive covenant if any part is overbroad. Even if only one clause is unreasonable, the whole agreement fails. This is the most employee-friendly approach because employers must draft carefully from the start. For example, if a non-compete bans work anywhere in the US, when only a local restriction is reasonable, the whole clause is voided. Blue pencil rule, strike, don't rewrite. Courts may strike out unenforceable portions but enforce the rest if it still makes sense. Judges cannot add or rewrite language, only delete. For example, if a non-compete covers Indiana, Illinois, Missouri, Ohio, Kentucky, but Kentucky is overbroad, the court may strike Kentucky and enforce the rest. Purple pencil rule, reformation modification courts have discretion to rewrite or reform overbroad terms to make them reasonable. This is the most employer-friendly approach because judges can adjust terms rather than void them. For example, if a clause bans competition in Kentucky but the employee only worked in Michigan, the court could replace Kentucky with Michigan. So, what is the bottom line for the pencil rules? Red pencil equals void the whole clause. Blue pencil equals strike the bad parts, enforce the rest. Purple pencil equals rewrite to make it reasonable. So, what happened? Well, here's where the court drew the line. White's covenants weren't tied to the sale of a business. They were just employment restrictions. His bargaining power wasn't greater than any other employee, and his merger profits were no different than the rest of the shareholders, most of whom never signed covenants at all. The appellate court reversed the trial court's decision. They held that non-compete covenants are unenforceable as ancillary to employment. The court warned that blue penciling overbroad covenants would gut the RETA personnel doctrine, letting employers draft outrageous restrictions knowing judges could rewrite them. So why does this case still matter today? For law students, this case reinforces the doctrine against blue penciling employment contracts. For citizens, bottom line, covenants must stand or fall as written. Since these were overbroad, they sank. No edits, no fixes, just unenforceable. Thanks for watching 99 Rights Online, where legal clarity goes viral. Hit subscribe for fast, viral explanations that you can understand and could actually help. If you want more landmark cases explained in plain language with powerful visuals, subscribe and share this video with friends. Because knowing how courts handle non-compete clauses can protect your career and your contracts. If this breakdown made the law feel a little less intimidating and a lot more powerful, don't scroll away just yet. Like, subscribe, and share to keep your rights sharp and your feed spicy. Because justice isn't just for lawyers, it's for everyone.